Hi, folks. Medicare open enrollment is simple. 1, call the number on your screen. 2, the agent will look up your zip code to see if you're able to eliminate copays and get Part C benefits like prescriptions and expanded coverage for your dental work at no extra cost. 3, check if you're eligible to get money added to your Social Security check up to $1,700 a year. Call to check your zip code.
I call to check my zip code.
I call to eliminate copays.
I call to get everything I deserve.
I call to get money added to my Social Security check.
People have trusted the Medicare coverage helpline. You can too. Call the 800 number on your screen to check your zip code. Don't miss the deadline. Call now. It's free.
Call 1-800-337-3200. That's 1-800-337-3200 now.
Oxygen knows in the world of true crime, some women uphold the law, some women break the law. Both can turn your world upside down. Oxygen is home to truly bold, truly wild, true crime.
I'm so late, I couldn't drag the bar.
I was in way over my head.
Everyone has a motive for watching. Oxygen. We live and breathe true crime.
Thanks for being with us here on Court TV Live this Tuesday afternoon. I'm Julie Grant. We continue on that verdict watch. An hour and a half now. The jury has been deliberating in Brunswick, Georgia. And with such a highly publicized trial like this one, it's hard to believe anything other than the case at hand could be taking center stage. But yet, over the past few weeks, one person continues to dominate the headlines. Defense attorney for William Roddy Bryan, Kevin Goff. We want to take a look back together now at some of his more unconventional moments throughout the case.
He's basically inviting jurors to just, like Dorothy, there's no place like home, there's no place like home, there's no place by home. We're indoctrinating jurors to say, I can be fair, I can be fair, I can be fair. What at first looks, when we all come in the courthouse on Monday morning, like a very innocent attempt by a civil rights group to promote voting rights, turns out to be something much different.
The court does not find that the movement has met its burden to limit the First Amendment rights of any individuals that may come to the courthouse grounds, which is a public place.
In this case, it would appear that white males born in the South over 40 years of age without a 4-year college degree, sometimes euphemistically known as Bubba or Joe Sixpack, seem to be significantly underrepresented. I can't say underrepresented in the entire panel of jurors because the race information on the master list is obviously not inaccurate. There's a real question in this case, whether that demographic is underrepresented in this jury pool. And if it is, then we have a problem with it. One issue is we renew our objection for service of the record to proceeding on Veterans Day. Compelling jurors to serve on this federal holiday, we would contend, is a violation of the jurors' rights. Whether they have formally filed objections or not, we don't know whether they know. They can tell the court if they have an issue, like if they have daycare, but it takes on a different kind of context. We maintain that it is illegal.
Yeah, I believe I've already addressed that. We're here.
The Right Reverend Al Sharpton managed to find his way into the back of the courtroom. I'm guessing he was somehow there at the invitation of the victim's family in this case. And I have nothing personally against Mr. Sharpton. My concern is that it's one thing for the family to be present. It's another thing to ask for the lawyers to be present. But if we're going to start a precedent, starting yesterday, we're going to bring high-profile members of the African-American community into the courtroom to sit with the family during the trial in the presence of the jury, I believe that's intimidating, and it's an attempt to pressure, could be consciously or unconsciously, an attempt to pressure or influence the jury.
So I'm not going to blanketly exclude members of the public from this courtroom. If individuals, based on the limitations that we have in the courtroom, end up sitting in the courtroom, and they can do so respectful of the court's process and in compliance with this court's orders with regard to the conduct of the trial, and they're not a distraction, then I'm not going to do anything about it.
How many pastors does the Arbery family have? We had the Reverend Al Sharpton here earlier, last week, and I'm not keeping track, and I think the court has indicated the court doesn't intend to ask anyone to keep track of who was in the gallery, but I don't know who Mr. Reverend Jackson is pastoring here. We are concerned about whether it's conscious or unconscious, the impact of their presence with respect to the jury and with respect to the proceedings in this case. And I guess the next question is, which pastor is next? Is Raphael Warnock going to be the next person appearing this afternoon? We don't know.
Mr. Goff, at this point, I'm not exactly sure what you're doing. I have already ruled on this court's position with regard to the gallery. The court's position hasn't changed. At this point, it's almost as if you're just trying to continue this for purposes other than just bringing it to the court's attention, and I find that objectionable from the court standpoint. I have said over and over and over in this trial that I am attempting to ensure that in this courtroom that the defendants receive a fair trial, and I will continue to do that. I have heard the objection. I have ruled previously on my position with regard to the gallery, and that is unchanged.
All right. So that was just a glimpse at some of the advocacy we have seen from attorney Kevin Goff. I want to bring in our attorney guest this hour on the program. She's joining us live from California. Trial attorney Christa Ramey is on the show today. Christa, great to see you. I know you've been watching this case unfold, and so I want to just ask you about the advocacy. What has jumped out at you in terms of the advocacy you've seen? What has really impressed you from these attorneys in this case?
You know, I think we've actually seen some very good lawyering, whether or not you agree with, we just watched that Kevin Goff package, and whether or not you agree with it or not, and some might say it was grandstanding. It was good lawyering. That's what you're supposed to do. But I have to tell you that Linda Dunikoski is one of the best prosecutors I've ever seen. Her rebuttal was right on, brilliant, exactly what you're supposed to do in a rebuttal, and the way she defined reasonable doubt for this jury this morning and what reasonable doubt actually means. It's a reason that you can articulate. I mean, that just was, spot on perfect. I think that we've seen some incredible lawyering.
Yeah, definitely, Christa. And you're going to be staying with us on the program today for more analysis. We're just at the bottom of the hour, which means we're going to squeeze in a quick break. When we come back, we have a special interview for you. As promised, we're going to be joined live in Brunswick, Georgia, outside of the courthouse by the attorney representing William Rodney Bryan, Kevin Goff. He's standing by. We're going to talk to him in just a moment. This is Court TV Live.
Tonight on Closing Arguments, we are in a verdict watch in the killing of Ahmaud Arbery murder trial. Was the prosecution able to convince this jury to convict all three of these defendants? Has the defense put up a strong enough case regarding citizen's arrest and self-defense? Our teams are on the ground bringing you every update as we await the jury's decision.
Closing Arguments with Vinnie Politan, tonight at 8/7 Central, only on Court TV.
This is an important message for everyone on Medicare. Attention, everyone on Medicare. Today we are talking about Medicare Part C, commonly called Medicare Advantage. If you don't have a Medicare Part C plan, you could be missing out on extra benefits simply not covered under Medicare Parts A and B. That's right, there are millions of people on Medicare but don't have a Medicare Part C plan, which covers everything in Part A and Part B, plus extra benefits only in Medicare Part C. Here's the good news. Everyone on Medicare can call now during the Medicare annual enrollment period. We will check to see if you are missing out on a Medicare Part C plan with additional benefits. Call the number on your screen. Don't wait. The deadline is December 7th, and phone lines get busy during the Medicare annual enrollment period. You don't get Medicare Part C benefits automatically, so call now before the deadline for your free, no-obligation Medicare benefits review. Just call 800-695-1455. 800-695-1455. This is an important message for everyone on Medicare. Attention, everyone on Medicare. Today we are talking about Medicare Part C, commonly called Medicare Advantage. If you don't have a Medicare Part C plan, you could be missing out on extra benefits simply not covered under Medicare Parts A and B. That's right, there are millions of people on Medicare but don't have a Medicare Part C plan, which covers everything in Part A and Part B, plus extra benefits only in Medicare Part C. Here's the good news. Everyone on Medicare can call now during the Medicare annual enrollment period. We will check to see if you are missing out on a Medicare Part C plan with additional benefits. Call the number on your screen. Don't wait. The deadline is December 7th, and phone lines get busy during the Medicare annual enrollment period. You don't get Medicare Part C benefits automatically, so call now before the deadline for your free, no-obligation Medicare benefits review. Just call 800-695-1455. 800-695-1455.
Every year, almost 30,000 babies in America are born with birth injuries such as cerebral palsy and brain damage. As a dad of two beautiful boys myself, it's every parent's worst nightmare. What you may not know is that too often, medical negligence may have caused your baby's brain damage, no matter what the doctor or hospital says. That's why we believe that every child born with brain damage deserves a chance to have their file looked at by our firm for free. Our dedicated staff of nurses, medical reviewers, and attorneys are standing by to take your call. And having represented parents just like you, we work with your family to determine if and how much compensation you deserve. As America's largest injury firm, we've recovered billions for our clients. And you can even sign up with our firm from the comfort of your home. If your child was born with brain damage, please call us to receive a free birth injury lawsuit brochure and learn more about how we can help. There's only one Morgan & Morgan for the people.
Call 844-400-9515.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. As we continue on that verdict watch in Brunswick, Georgia, we have a special guest joining us on the program this afternoon, one of the attorneys involved in the case. Kevin Goff, the attorney who represents William Roddy Bryan, is joining us now live outside of the courthouse. Mr. Goff, thank you so much for your time on this very important day. My first question for you is, how are you feeling right now?
Tired, exhausted. It's been a long month, 5 or 6 weeks, I've lost track, but we're almost there. We've got a jury out and they're deliberating, and certainly I don't want to say anything that could impact that process. I certainly hope our elected officials, from the local ones all the way up to the very top, will likewise reserve making any comments that might influence a jury one way or another. We've all worked so hard for this process, and we would be ashamed for anything to spoil it now. Mm-hmm. So what can I tell you with that understanding?
Mm-hmm. Well, we have lots of questions for you, and answer as you're able to answer. Let's start with one question that I've had in my mind since I saw you rest without putting on a defense. And that is why. And I want to preface that question by saying that we understand that your client doesn't have to put on a shred of evidence. He is presumed innocent, cloaked in the presumption of innocence. I just thought, knowing how passionate you have been about this case and seeing so many of the arguments you and your colleagues have put forth, I was expecting to see a defense. Can you shed some light as to why no witnesses were called, please?
Well, we did present a defense. You'll recall that Roddy Bryan provided the video that is at the heart of this case. He provided the Night Owl videos. That's technically our evidence because it shows his good faith. That was our evidence. And a lot of the evidence the state presented was actually exculpatory evidence for Mr. Bryan. So although the exhibits may have state numbers on them, they are, practically speaking, a lot of those are defense exhibits. And they covered a lot of the ground that needed to be covered. So we're comfortable with the case that's been presented to the jury.
Mr. Goff, I know you've always been comfortable from day one having this case tried in Glynn County, where the incident in question occurred. I know hindsight is 20/20, but want to ask you now that the evidence is all in and the case is coming to a close, is there any regret in not pushing for a change of venue?
No, ma'am. This is the place the case needed to be tried. We've had some concerns and some questions. We've raised them by motion through the proceedings. but the event took place here. You've got a family here that wants their day in court. You've got 3 other families. They want their day in court. That needs to happen here in Brunswick, Georgia. We have a wonderful court system. We have a wonderful sheriff. We have great people in law enforcement, great people in this community. And I think that you've seen that they've all been working very, very hard to ensure that we could have this trial in this town.
Tell us, is there a reason you kept resurrecting the issue of not wanting to have black pastors sitting in the courtroom gallery when I know we both know, anyone who practices law knows, there's no legal basis for exclusion in the courtroom. In America, courtrooms are public. So is there a reason why you continue to resurrect that issue day after day?
Well, I'll say this, that I'm not going to start having that discussion outside the courtroom before a jury returns its verdict. I don't think that would be appropriate. And I would beg to differ with you. I think if you go back and you look at the law, read it a bit more carefully, you'll see that the motions filed have ample legal basis. And I'm sorry that some people are reading more into these things than there are. Sometimes I feel I get far too much credit. But we're comfortable with the legal basis for the motions that were filed.
What is the legal basis you're saying that there is? Because in America, courtrooms are public. What is the legal basis you're citing?
There's a lot more to it than that. But again, with the jury out deliberating, I'm not going to get into that stuff. We've made our arguments in court. We filed our pleadings in court. The court's made its rulings. The jury is out. And until the jury returns its verdict, I'm not going to say anything outside that courtroom that could in any way impact that process. And I know you respect that. And if you want to take up this conversation perhaps again, I'd be more than happy to have it. But I'm not going to do it while an unsequestered jury is deliberating on this case. And I'm sure you can appreciate why.
Sure. Well, let's talk about that, because that actually is a question I have for you. Why wouldn't you want them to be sequestered, especially in light of everything that you raised in the courtroom about your concerns about so many people gathering outside? Yesterday you said it had become a literal mob, not a figurative mob. Those were your words when you resurrected your 8th motion for mistrial just on that issue.
Well, I'm not going to discuss the security precautions that have been taken by the court. I don't think it would be appropriate. There's been a lot of work done to ensure, if not the anonymity of the jurors, their privacy. So, it's hard for me to respond to that right now.
Why you wouldn't want the jury sequestered? You can't say?
Whether the jury needs to be sequestered depends in part on what arrangements have been made as we speak today with respect to the jurors, and I'm not going to discuss those. Not that I am necessarily privy to all that, but even if I was, I just don't think that we need to be having that conversation right now while the jury's deliberating. And I'm sorry if that's frustrating, but that's just the best I can tell you right now.
I understand. We'll respect that. Let's move on to something else that has a lot of people talking, as I'm sure you know, and that was your colleague in this case, Laura Hogue, who represents Gregory McMichael. She made the comment yesterday in closing arguments about Ahmaud Arbery's toenails being long and dirty. And it got a lot of discussion after the court proceedings had concluded for the day. Ahmaud Arbery's mother, very upset, feeling that it was a disparaging comment. We're curious, what did you think of the comment, please?
Well, what I think is that Laura Hogue is an excellent attorney. She's provided incredible representation for Greg McMichael. And I'm not in her shoes. I'm representing a different client. So it's hard for me to speak to what she did. On behalf of Mr. Bryan, I probably would have not commented on that. But then again, I represent a different client, different situation. And all I can tell you is she is a fine lawyer. She has a great legal mind, and everything she does, I feel pretty confident in saying it's thought out. Sometimes difficult things need to be raised. If the lawyers are afraid to talk about it, how can you expect the jury to do that? And I don't know if that impacted her thought process. I don't know what the thought process was, But I would be reluctant personally to be critical of such a fine attorney without knowing exactly what the thought process was. But you also got to remember now, I'm sitting behind the other attorneys as they're giving their closing arguments, and I can't see what y'all are seeing during the trial. You also have to remember this is a challenging case for the lawyers because of the masks that the jurors are wearing in the courtroom. We can't get the usual feedback. And, you know, I think certainly for you and some of the other folks at Court TV, you can appreciate the importance of having that feedback. So without the benefit of that, sometimes it's harder to assess or predict what's going on with the jury. So, you know, I don't know what impact that had on the arguments that were not made by the other lawyers yesterday.
Understood. Tell me, we know one of the very highly contested issues outside the presence of the jury was the admissibility of a statement that Travis McMichael allegedly made after Ahmaud Arbery was shot and killed using an expletive and then the N-word. And we know ultimately, because of a very famous case in the United States of America, the Bruton case, if your client, Roddy Bryan, was not going to take the stand and be available for cross-examination on that because he's the only person who would be able to relate that, it can't come in against Travis McMichael, even though it's his statement. And we unpack this a lot here on the show, Mr. Goff. And, you know, I am wondering about something that Travis McMichael's attorneys shared with Court TV just a few days ago when they came on our programming, and they said it's their belief that your client never heard that statement made by Travis, that he was just saying this to investigators in order to procure a deal for himself. Your response to that, please.
Well, my response to that, and I know you're going to be frustrated with me, is that the jury's out in this case, and I'm not going to discuss the evidence that was presented in front of them, nor am I going to discuss evidence that was not presented in front of them until they've returned a verdict. Yeah, there's a lot I could say in response to all that, but I just don't think this is the time or the place. Maybe we'll have this conversation again later.
Okay.
Because I don't want to do or say anything here that could negatively impact the co-defendants. They also have a right to a fair trial.
Certainly understand that. We respect that. And we, of course, would invite you back on any time you are available for us to talk about some of these issues that you just cannot legally discuss today because of the situation. And right now with this jury out deliberating for an hour and 51 minutes. So with that, just want to say thank you very much for your time, Mr. Goff. Thank you for making time for us. And we'll let you head back into the courtroom and hopefully get a chance to speak with you again soon.
Thank you so much. Have a good afternoon.
Take good care. You as well. And with that, we're going to squeeze in a quick break here on Court TV Live. When we come back, we have more analysis for you and reporting on what is happening in Brunswick as this trial is coming to a close. This is Court TV Live, your front row seat to justice.
If you, like many people, are covered by both Medicare and your state's Medicaid, here's something important to know. Medicare annual enrollment is here and ends December 7th. So now's a great time to look at a United Healthcare Dual Complete plan. It could give you even more health benefits than you already have. To find out if you or someone you care about is eligible, it's easy. Call now to talk with us. We can explain it all and answer your questions. Medicaid gives you benefits, and Medicare gives you some too. But a dual complete plan can add even more benefits and features compared to original Medicare. You'll get $0 copays on all covered prescriptions, including brand names. And depending on where you live, you could enjoy other benefits too, like more dental care and rides to and from your doctor or pharmacy. Most plans even give you up to $150 a month on a prepaid card for covered over-the-counter products and groceries. And best of all, with this plan, there's no extra cost to you. Remember, if you have Medicare and Medicaid, chances are you could get a dual complete plan. So call now to talk with us. Our agents are available to help. We know healthcare can be confusing. United Healthcare can straighten things out. And with over 40 years of experience, you can count on us to be there for you. With With a Dual Complete plan, you could have $0 copays on all covered prescriptions, a prepaid card for covered over-the-counter products and groceries, more dental coverage too, all at no extra cost. If you have both Medicare and Medicaid, you may be eligible for Dual Complete. Hurry, annual enrollment ends December 7th, so call the number on your screen now to see if you're eligible or to enroll. There's more for you with the United Healthcare Dual Complete plan.
Hi, folks. Joe Namath here to alert you to an important Medicare deadline. You may be able to get Part C benefits, including prescriptions, transportation, meals, and coverage for dental work with extractions, fillings, even dentures, all at no additional cost. Plus, depending on your zip code, the benefit that adds money to your Social Security check every single month. Call to check your zip code and get what you deserve. It's free.
I call to save money on copays and get prescriptions, transportation, and my dental work covered. I couldn't believe I was spending money I don't have to spend.
I'm on a fixed income, so I called to get money added to my Social Security check.
Before the Medicare open enrollment deadline, you may be able to get extra benefits and get money added to your Social Security check every single month. It's simple. 1, call the number on your screen. 2, the live agent will check your zip code to see if you're able to eliminate copays and get prescriptions, transportation, meals, and expanded coverage for dental work with extractions, fillings, even dentures, all at no additional cost. And 3, they'll check if you're eligible to get benefits that add money to your Social Security check every single month, up to $1,700 a year. Call to check your zip code and don't miss the deadline.
I called to eliminate copays.
I called to check my zip code.
I called to get everything I deserve.
I called to get money added to my Social Security check.
Millions of people have trusted the Medicare coverage helpline. You can too. Call the 800 number on your screen to check your zip code. Don't miss the deadline. Call now. It's free.
Call 1-800-778-7100. That's 1-800-778-7100 now.
In Atlanta. Now, I don't know if you've watched.
You are watching Court TV Live, your front row seat to justice. I'm Julie Grant. We are on a verdict watch here in the case of the 3 men accused of murdering Ahmaud Arbery. The jury's out for almost 2 hours now. This morning, though, before they were instructed by the judge on what the law is that they'll apply to the facts of this case, they heard the rebuttal from the state of Georgia, delivered by the lead prosecutor on this case, Linda Dunikoski. She has been the consistent, strongest voice they've seen throughout this case from the state. She did the opening statement, she did the closing argument, and then the rebuttal. And we want to play for you a portion today, a portion of it where she focused in on what arguably is the biggest issue for this jury to sort through, whether or not there was a proper citizen's arrest happening. Let's take a look at what she said.
A private person may arrest offender if the offense is committed in his presence. Okay? You can arrest if the offense is committed in his presence. If the offense, and that's my parenthetical to remind you, if the offense, we're talking about that offense, the one that was just committed in your presence is a felony, and the offender is escaping or attempting to escape right then and there.
Judge, that is not the law that the court's going to give, and we've had this discussion. We've talked about it. In the statement of law, we would object.
I join the objection. It's noted.
You understand this is my argument. The judge is going to give you the law, right? And he's going to have it written out for you, and he's going to read it to you. But this is the state's argument, that the offender is escaping or attempting to escape. The state's position is that what that means is, I saw the crime, I can't chase after the person, I just have to try and arrest them right there. But if it's a felony, and if they're escaping, they're running away, I get to chase after them. I don't get to chase after them unless it's a felony and they're trying to escape. All right? A private person may arrest him upon reasonable and probable grounds of suspicion. That's the state's position.
We have to object and have a conference with the court. No, we're going to let the state continue. We talked about this in the charge conference. The objection is noted.
We move from this charge.
Based on the incorrect statement of the law.
All right, I want to bring in our guest on the program for some analysis. Christa Ramey, trial attorney, joining us in California on the program today. Christa, tell me, how do you see this issue playing out with this jury? Do you think this is going to be something that they might struggle with?
Why?
Well, yes, because it's kind of the crux of the justification for stopping him and the use of deadly force in self-defense, right? But whether or not it is, believable or how much time they'll spend on it, it's anybody's guess. I think that, in reality, Linda Donikoski did an incredible job at addressing this, particularly in her rebuttal. And when the defense is literally lighting their hair on fire to get you to stop talking about it, her arguments are making sense and they're landing well. I mean, these were incredibly well thought out arguments that were landing well. The defense's interpretation of this law and argument of this law to the jury was very strained. And so I think that when you have to, the proverb, usually the simplest explanation is the correct explanation. I think that is what we're seeing here, played out in front of us, that we have a very simple explanation that this crime must have been in your presence and it must have been, immediately happening in order for you to do this. So I think that she did a great job explaining it to the jury today.
Yeah, she really did. I couldn't agree with you more, Christa. And that statute essentially is saying, and this is the words direct from statute, the offense has to be committed in his presence or within his immediate knowledge. And that's a place where I always felt like the defense is going to struggle here with this, because we know no crime was committed in their presence, and we know, especially from Gregory McMichael's statement to law enforcement, not within their immediate knowledge. Anything that was learned about all of this was, after the fact here. And so I think this is going to be really, really tricky and tough to get around for this defense team. Tell me, at the end of the day, Christa, it seems like all of these attorneys on both sides have left no stone unturned. They can all be applauded for, it seems like, doing everything they can think of under the sun to advocate for their respective positions. When you are in trial and in a case like this that is so meaningful and high profile, what more can you really ask for than just giving it your very best?
Well, that's it. I'm actually in trial right now. We're dark this week. And, I know this battle that they're going through right now. And it is a battle. You never know what's going to happen on the other side. And you have to go in knowing every piece of evidence, not relying on someone else to look at the evidence for you is a mistake. You need to have a good understanding of how you're going to present your case, and you have to be relentless. And that's what we've seen here. We've seen, whether or not you like I said earlier, whether or not you like how they presented their case or the arguments that they've made, they are doing what they're supposed to do. But, I think at the end of the day, what we have here is, when the cops stop you, after it's all said and done, well, I don't know what he was doing, but he was running. There was the black man running in my neighborhood. Whatever you find out later, you can't change that fact. You had no business stopping him. And I think that really, the evidence really came out today. And I think that put together today, that came to a nice conclusion today in terms of the presentation. So well done.
Right. Definitely. Christa Ramey, great having you on the show today. We have to say goodbye to you. Thank you so much for being with us. And thank you at home for being with us as well. We're watching that jury deliberation clock, 2 hours and counting. It's where we are. As soon as the verdict is reached, you'll see it right here on Court TV Live.
Tonight on Closing Arguments, we are in a verdict watch in the killing of Ahmaud Arbery murder trial. Was the prosecution able to convince this jury to convict all three of these defendants? Has the defense put up a strong enough case regarding citizen's arrest and self-defense? Our teams are on the ground bringing you every update as we await the jury's decision.
Closing Arguments with Vinnie Politan, tonight at 8/7 Central, only on Court TV.
Like, you got the bags.
Hi, my name is Sam Davis, and I'm going to tell you about exciting Medicare Advantage plans that can provide broad coverage and still may save you money on monthly premiums and prescription drugs. With Original Medicare, you're covered for hospital stays and doctor office visits, but you have to meet a deductible for each, and then you're still responsible for 20% of the cost. Next, let's look at a Medicare supplement plan. As you can see, they cover the same things as Original Medicare, and they also cover your Medicare deductibles and co-insurance, but they often have higher monthly premiums and no prescription drug coverage. Now, let's take a look at Humana's Medicare Advantage plans. With a Humana Medicare Advantage plan, hospital stays, doctor office visits, and your Original Medicare deductibles are covered. And of course, most Humana Medicare Advantage plans include prescription drug coverage. In fact, in 2020, Humana Medicare Advantage prescription drug plan members saved an estimated $8,400 on average on their prescription costs. Most Humana Medicare Advantage plans include a Silver Sneakers fitness program at no extra cost. Dental, vision, and hearing coverage is included with most Humana Medicare Advantage plans. And you get telehealth coverage with a $0 copay. You get all this for as low as a $0 monthly plan premium in many areas. And your doctor and hospital may already be a part of Humana's large network. If you want the facts, call right now for the free decision guide from Humana. There is no obligation, so call the number on your screen right now to see if your doctor is in our network, to find out if you can save on your prescriptions, and to get our free decision guide. Humana, a more human way to healthcare.
If you have COPD, asthma, chronic bronchitis, or emphysema, we can help you breathe a little easier. Med4Home may be the solution to your breathing problems with our portable nebulizer and medications. Independent studies have shown a nebulizer can be easier to use and more effective than an inhaler. And with Medicare, your nebulizer and medications may be covered by your Part B benefits. We're a specialty pharmacy that has been helping people since 1998. Call Med4Home today, and we'll do whatever we can to make things easier. We deal directly with your doctor, handle all the paperwork, deliver to your door with no additional cost for shipping, and our pharmacists and respiratory therapists are there for you 24/7. So call Med4Home now to see how our portable nebulizer and medications can help you breathe easier.
For more information, call 1-800-306-8835. That's 1-800-306-8835.
I ended up losing my job because of COVID. My biggest stress, I think, was not knowing how I was going to be able to afford my medication. I went to the pharmacist and I asked her if there was anything that she could help me with, and she's like, I already got it. Don't worry about it. Here's GoRx. It was a huge chunk of change, like a good 75% that I ended up saving. I was like jumping up and down. Yeah! I just couldn't be more grateful.
Welcome back to Court TV Live. I'm Ashley Wilcott, honored to be with you an hour earlier today from 2 to 5, where we are on verdict watch in the trial of 3 men accused of murdering Ahmaud Arbery. If you'll take a look on your screen, 2 hours, 6 minutes. That's how long the jury has been deliberating. They started earlier this morning. The fate of Travis and Greg McMichael and their neighbor William Roddy Bryan are now in the hands of that jury.
Remember, this isn't about having personal baggage back in the jury room. It's not about a point of view or an agenda or anything like that. That's not what's going on.
The prosecution is asking the jurors to remove their personal feelings from the deliberations. That while reaction continues to pour in about what could be called a personal dig.
In his khaki shorts with no socks to cover his long, dirty toenails.
Many, including Ahmaud Arbery's mother, found the defense's dirty toenails comment insulting. We are certainly going to have more on that later. But first, let's get you caught up with the latest on the McMichael trial. Judge Timothy Walmsley finished charging the jury with instructions just before 11:30 a.m. Eastern. This morning, the state gave its rebuttals to the defense's closing arguments, and there were sparks. The prosecutor in this case, Linda Dunikowski, highlighted to the jury the importance of the parenthetical citizen's arrest law, which led the defense moving for a mistrial based on what they claimed to be an incorrect statement of the law. Let's take a listen.
A private person may arrest offender if the offense is committed in his presence. Okay? You can arrest if the offense is committed in his presence. If the offense, and that's my parenthetical to remind you, if the offense, we're talking about that offense, the one that was just committed in your presence is a felony, and the offender is escaping or attempting to escape right then and there.
That is not the law that the court's going to give, and we've had this discussion. We've talked about it. In the statement of law, we would object.
I join in the objection. It's noted.
You understand this is my argument. The judge is going to give you the law, right? And he's going to have it written out for you, and he's going to read it to you. But this is the state's argument, that the offender is escaping or attempting to escape. The state's position is that what that means is, I saw the crime, I can't chase after the person, I just have to try and arrest them right there. But if it's a felony, and if they're escaping, they're running away, I get to chase after them. I don't get to chase after them unless it's a felony and they're trying to escape. All right? A private person may arrest him upon reasonable and probable grounds of suspicion. That's the state's position.
We have to object and have a conference with the court.
We will let the state continue. We talked about this in the charge conference. The objection is noted.
We move from this trial based on the incorrect statement of the law.
Your Honor, based on the final draft of the charge that the court provided us, I guess yesterday morning, the court is going to charge that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during escape. If the observer fails to make the arrest immediately after the commission of the offense, or during escape in the case of felonies, his power to do so is extinguished. That's not what the state's arguing. They're arguing and it's a clear misstatement. The court should simply instruct the state not to argue an incorrect statement of law rather than putting the burden back on the jury to understand what the state's saying, what we're saying, and now what the charge is saying. The court has the power to do so and should do so.
Let's go now live to Court TV legal correspondent Julia Janae outside the Glenn County Courthouse. Julia, I know you've been there covering this case since the very beginning. Tell us, if you would please, first, updates for today.
Right now, this jury has been out. We see there 2 hours and 11 minutes. Right before lunch is when they got this case, but we haven't heard anything from them yet. Not a note, not any requests when it comes to how long they're going to deliberate today. Our understanding is they will let the court know when they want to go home, and the judge is going to let them deliberate as long as they want to. So they are there. We know that the alternates are still members of the jury. They're still sworn. They are not fully released, but they are not, of course, in that deliberation room. So we're standing by to see if we're going to hear anything from that courtroom.
You know, just in terms of logistics, Julia, we just watched this in the Rittenhouse trial and what happened to the alternates. I know you referenced that certainly they've not been excused. They're there in case they're needed. Are they in a different room? Are they allowed any type of anything that they can do while they wait? Or are they basically just in a room having to wait unless and until called or released?
You know, I don't know the logistics on their service at this point, because they have been very careful about letting us know where the jury is in their movements, which is understandable in a case like this, especially with the concern about outside influences and things that they don't want this jury to be hearing that's outside. So in terms of what's going to happen with them, we don't know, but we know there has been a concern from the defense on whether or not these protesters and demonstrators that are outside the courthouse, not nearly as many as we've seen on other days. There's probably about 50 to 75 people here today, and that's including a lot of media. But they are on one side of the courthouse that you see behind me. You see the white tent. That's where many of the people are, security, and the media poised for a press conference. But on the other side is where the jury comes and goes. And they really want to keep the public public on this side of the courthouse so that they are not in any way interfering with the jury.
And one of the interesting dynamics to me in this case, Julia, is the fact that we know that you have, for instance, Defense Attorney Goff, who is from that area, practices law in that area. We know that we have Bob Rubin as well as Jason Sheffield representing the son, Travis McMichael. They are from Atlanta, Georgia, which is 5 hours north of Brunswick, Georgia. We also know that this prosecutor is from Cobb County, which is close to Atlanta, Georgia. So again, not from that area, yet the jury is